Welcome to Law Sessions. I'm Jennifer Housen. In this law session, we will explore the whole area of public order law, and we'll also look at state security. It is an interesting area, and indeed, if you choose to do this as a topic, now generally in public law, this may not necessarily come as a standard type question, for example, like let's say separation of powers, rule of law, and the like. But if it is that you manage to grasp this area, it really is a good topic for you to take on board in respect of one of your topics. Again, examiners say don't topic pick. I agree with them, but only to a point, because after you've done the entire syllabus, you really need to focus on some particular areas. And I do say to students, if you're going to focus, you really must be focusing on at least 6 areas that you have done in extraordinary depth, have done the questions, done reviews. However, please make sure that as well you've looked at the past exam questions. You can't focus on, say, 3 areas or 4 areas. That's not terribly clever. So public order law and state security is one of those areas that will not normally come all the time on an exam paper, but when it comes, and if you know the topic clearly good enough, then you will be fine. What we will review, of course, is looking at this whole idea of what public order law is. We will spend the first half of the law session looking at public order, and then we'll look at the remainder of the session considering state security. Now, public order law seeks to balance 2 competing interests. It looks at the right to freedom of expression and freedom of assembly on the one hand, and then on the other, the right of all citizens to an orderly society. I would suggest that you get to grips with the provisions of the Public Order Act as amended, and that you should be able, from reviewing it, to assess what the points are under the Act, and to be able to apply them to an exam question that you get. You also need to know the case law that has pretty much come up under Article 11 of the European Convention, as well as most of the emerging case law under the Human Rights Act 1998. So I would urge you to review the other law sessions in this area, in particular the Human Rights Act law session. Now, to understand the impact of public order law, you need to know about civil liberties. What is civil liberties? Well, in short, civil liberties is a sort of umbrella term which more or less covers a range of freedoms and rights which are protected under the law. So, if you have listened to the other law sessions, you should have an understanding of the importance of civil liberties under the Constitution, not least when you listen to the Human Rights Act law session. What we will cover in this law session is the law relating to freedom of expression and its limitations under the law. While you do need to know the provisions of domestic law, you also need to, of course, keep in mind the protection under the European Convention and the Human Rights Act. Now, if you look at, for example, freedom from discrimination, freedom of expression, the right to associate and assemble with others in order to exchange opinions, these are all hallmarks of a civilized, democratic society. The traditional approach, of course, to such freedoms and rights under the United Kingdom's unwritten constitution is to see them as freedoms to act other than where the law restricts the activity in question. Now, although our focus is on freedom of expression, freedom of assembly and association do bear in mind that there are numerous other rights and freedoms that have long been protected under the law. Now, what are these other rights and freedoms that I'm asking you to bear in mind? Well, think about trial by jury, for example. It goes back as far back as the Magna Carta of 1215. When you look at the ancient writ of habeas corpus, and although it is not used so predominantly nowadays, because frankly the whole judicial review proceedings has by and large overtaken it, as well as the European Convention on Human Rights, it still exists in order to challenge the legality of a person's detention. Equally, when you look at this whole area of police powers and the control of police powers, it is important in relation to this whole notion of civil liberties law. So, for example, the individual's freedom is protected by rules relating to arrest and the power of the police to stop and search suspects. So when you look at the Police and Criminal Evidence Act, which came in 1984, it set out precisely what police officers had to do when they stopped someone, what information they had to give them, and all of this. Because the idea is that you ought not to, as the police, stop somebody simply because of their ethnicity or because of the way they look. There really should be some basis for this stop. And indeed, if you take it further for a search, there should be some basis for this search, because the whole idea of civil liberties and the protection of civil liberties is that the state and the state actors, which the police are, ought not to trample on those rights as you have. Now, freedom is also protected by the requirement that any surveillance by the police or invasions of privacy through interception must be authorized by statute, and we will see that shortly. Now, where we get deficiencies in the protection of civil liberties, these have led to calls for reform. And for a long time, there really was nothing that someone could pin their rights on. But with the coming into force of the Human Rights Act in 1998, which again, I refer you back to that law session, there is now a framework which is provided for in respect of the jurisdictional base for many challenges which can be tested in domestic courts. When you look at these freedoms and these rights, the fact is that they do carry, to an extent, responsibilities with them. But one of the things that is interesting is that when you look, for example, at the Human Rights Act, it does not, for example, go to the extent of, for example, the United Nations Declaration of Human Rights, which sets out freedoms, but it also sets out rights, but it also sets out responsibilities. And that is an interesting conundrum, because you have this right to a private life, and when you look, for example, at the persons who are calling for the right to their private or family life, are precisely people who generally are breaking the law. So, for example, you may very well get someone, take on board the Abu Qatada case, for example. We see him saying, well, if I go back to Jordan, then my rights will be trampled on. But then consider even his stay in the UK is somewhat tenuous, and we have the UK making a deportation order. The point, of course, is that when you look at the European Convention on Human Rights, it seems to have rights, but the responsibilities are by and large absent. Now, one person's freedom may be another person's loss of freedom. It simply isn't possible for everyone to exercise rights to freedom of speech at the same time, for example, for no one then to be heard. So I may have a freedom of speech, but it doesn't mean that I can say anything I like to the point of, for example, harming someone either personally or financially. Now, these rights have as against them other competing legal issues. So even the right to free speech is somewhat limited when you look at, for example, defamation. Now, when you even consider what has just gone on through the Leveson inquiry, have a look at that, because what we see here is this whole inquiry looking at how newspapers have conducted themselves, how the media have conducted themselves. The media at all times will seek to draw on right to free speech. But is that right to free speech an unrestricted, do whatever I like kind of right? Not necessarily. So when you look at even those kind of rights, you have to consider, well, what are the civil liberties are in relation to that. Remember, we're still doing public order. What we need to understand is what are civil liberties in order, for example, to know when these rights are being infringed in terms of the public order law. Now, as we can see, there needs, by and large, to be some restriction when we look at how people exercise the rights. And so when individuals seek, for example, freedom in respect to assembly or any other type of freedom, then it must be that each individual's sphere of freedom must be such that it is consistent with the freedom of other persons. Now then, everybody is free within a legal confine. It simply cannot be that everybody is free to do something. It must be that you're free, but within a legal framework. Now, if you look at the main textbook, The Constitutional Law by Hilaire Barnett, it is a very good book for this area, and I cannot stress its importance. Now, it looks at, for example, freedom to the extent that it has confinement. So, for example, the right to express and exchange information and opinion lies at the heart of the democratic process. Now, without freedom of speech, there could be no political dialogue, no criticism of government, or freedom of debate. Freedom of speech, however, cannot be unrestricted. There must be legal restrictions which ensure that the exercise of free speech does not injure the rights and freedoms of others. In order to understand the scope of the freedom, therefore, it is necessary to consider the limitations and the range of the limitations which are imposed on it. Now then, if you look at Article 10 of the European Convention of Human Rights, which guarantees freedom of speech, again, it looks at the limitation on that exercise. So, there are restrictions. The restrictions on freedom of expression under English law may be summarized as follows. 1. The law of defamation, meaning libel and slander, curtails it to the extent that you can, for example, express yourself freely. The law relating to sedition, incitement to disaffection. So you can't start saying, let's kill the government, for example, and do it in a way where it is by and large seditious. The law relating to racial hatred. There are laws relating to inciting racial violence. And that, of course, means you can't just go out and say, right, make statements relating to a particular ethnic group, for example. The law relating to inciting a breach of the peace is curtailed. The law relating to pornography, broadcasting, conspiracy to corrupt public morals, official secrecy, and, for example, the law relating to terrorism. Now then, it is an interesting area for you to consider, as I say, what the rights are, but then also consider what the restrictions are. Because Article 10 of the ECHR, based on this right to freedom of expression, which of course includes the freedom to hold opinions, to receive and impart information and ideas without interference, are all freedoms you have. However, as I say, it may very well be that there are restrictions on these rights. There is one case that is very important that I need you to certainly look at, but I will give it to you in brief. It's a case of Max Mosley and News Group newspapers in 2008. And the courts in that case consider the applicant's right to privacy and the newspaper's right to freedom of expression. Because since 1993, Mr. Mosley had been the president of the governing body of motorsport worldwide and was therefore a public figure. Now, Mr. Mosley sought an injunction restraining the News of the World newspaper from further publication of details of his sexual activities with a group of prostitutes. Now, there was a videotape of the activities which had been made by one of the participating prostitutes and had been widely available on different websites. Now, Mr. Mosley sought to engage Article 8, which of course it could be engaged, it was his private life. Mr. Mosley did not dispute that the evidence occurred. In fact, he wasn't bothered about this whole idea of him being seen with prostitutes. But he did dispute the News of the World's claim that the activities amount to Nazi role play, because it wasn't that he was cavorting with prostitutes that really upset him. It was the fact that they showed him dressed up as a Nazi, and he was most put out by that because he is in fact the son of Sir Oswald Mosley, who is the founder of the British National Party, and at all times Mr. Mosley in this case had always rejected his father's past, and the paper was basically saying that him dressing up as a Nazi in this whole thing with this group prostitute thing was by and large hypocritical. Now, he was saying that the allegation was defamatory, and he made this application, and he said that the newspaper infringes right to privacy, and therefore he said, I am not looking at a defamation claim, I'm looking at the fact that they infringe my privacy. All right, because if he had brought his defamation claim, of course, that would have been a clear defamatory situation. Unfortunately, of course, truth is a defense to a defamation claim. Now, the News of the World defended the publication on the basis that it was in the public interest, and therefore Mr. Mosley's claim was of course denied, and the courts looked at a couple of cases which had come before it, Campbell and the MGN to do with Naomi Campbell, and Douglas and Hello, which had to do with Michael Douglas, of course, and they considered the correct approach and said, when you look at conflicting convention rights, so when you look at the rights at issue here, Mr. Justice Edie explained that an order would make little practical difference. Mr. Mosley no longer has any reasonable expectation of privacy. The now widely familiar material that was out there had entered the public domain, and to the extent that there is in any practical terms, he said there was no longer anything which the law could protect. Mr. Mosley was not happy. He took it to the European Court of Human Rights, but he also failed there. I'm going to take a short break, and when we return, of course, we will carry on looking at this era in terms of civil liberties, and we will, of course, consider this idea of freedom of association and assembly, which takes us neatly into the discussion relating to, of course, public order.